A patent is a negative right. It gives you the right to stop somebody else. It doesn't give you a right to do anything.
What's the starting point?
You can easily spend a lot of money on IP and go nowhere, like I said. So before you spend any money, let's do some education and understanding.
Where is IP? What's the trajectory of IP over the next few years?
Certain cases, trade secret cases, are criminal in nature. You can go to prison for trade secret theft. Client retention is a very important metric for us these days.
Welcome to the podcast From Cold to Close. My name is Saeed and I'm the founder here at SRC Growth Partner, a growth company that helps professional services firms from around the world increase their revenue and profitability by acquiring new clients. My guest today is Donal O'Connell, the founder and managing partner of Chawton Innovation Services, a company focused on intellectual property education and training, IP consultancy, and IP solutions and tools. He has completed over 200 IP-related consultancy projects, some narrow scope tactical IP projects, and some broad scope strategic IP projects for SMEs, MNEs, IP law firms, financial services firms, and universities. Since 2013, Donal has been included into the IAM 300, the world's leading IP strategists, an annual listing of those individuals identified as offering operating companies and other IP owners world-class advice on maximizing the value of their intellectual property. Donal, welcome to the podcast.
Thank you.
Yeah, no, I'm really looking forward to this conversation. I think we're going to be discussing a topic today that I feel probably isn't widely understood by many people, especially business owners, but also a very important topic to have awareness over as a business owner, as someone within an organization or a leadership position within a business. So before we jump into that, I guess the best place to start for our viewers and listeners is giving them an opportunity or giving you an opportunity to share who you are and what you do at Chawton Innovation.
Well, you've covered all of it, so I won't repeat what you've said already. Perhaps just to highlight a few additional things. So before Chawton, I was director of IP at Nokia, the mobile phone company. And before that, I was vice president of research and development. So in my earlier career, went up through the traditional engineering career ladder, engineering manager, up to VP of R&D. I've been involved in IP now for 20 plus years. I'm still learning about it because it's a complex subject matter, unfortunately. So if you stand still, you will start going backwards. I teach regularly. I've taught a number of electives at Imperial College Business School, other universities. I write regularly about IP as well. I'm on my 5th book at the moment, and I've had about 200 papers published. So I find writing about it, if I can capture my thoughts on a bit of paper, it sort of helps me at least sanity check that I'm started to gain an understanding of this aspect of IP. But no, I think you've covered my background well. So they were probably the only few things I'd like to add.
Perfect. And I guess the next place I want to really go into is what exactly is intellectual property and why do you think it's so widely misunderstood in the business world?
First of all, it's not one thing. It's an umbrella term. So you need to understand it's made up of different forms or different models and different processes. What is it? Well, if you look at the World Intellectual Property Office, which is a branch of the United Nations responsible for coordinating IP matters globally, based in Geneva, they start by describing it as being related to innovative or creative issues or topics, and then how one goes about protecting those. So its definition actually recognizes that it's not one thing. It can be inventive ideas, it can be creative works, it can be brands and logos and so forth. And then the IP is how one goes about protecting those different forms of innovation and creativity. So that's one definition. And that's probably the way that most people start explaining IP. They say, well, it's made up of these different things. And to be honest, today there are probably 20 or more different forms of IP. Some have more coverage or get more attention than others, but there's lots of different forms, which we'll come to later. However, if we were to walk down a high street and call into an accountant's firm and say, what is IP? They would give a slightly different answer. They'd say, well, it's an asset class. Just like you have assets like physical assets like houses and cars or stock, IP is an asset. It has value. You can put a formal valuation on it. You can keep it, you can buy it, you can sell it, you can license it, you can give it away for free. So it's also an asset. And one needs to think about it in that context. And actually, if you even go further and called into a tax firm, perhaps next door to the accountancy firm, they would say, actually, it's interesting to the tax authorities as well, because more and more the value of companies is related to their IP or their intangible assets. And we're interested in what companies are doing with it. And are they trading it? Are they generating revenue? Well, then that also needs to be considered. You could also see it as a management system for innovation and creativity. If your business is involved in anything innovative or creative, well, then you've got to think about, well, how do I manage that in terms of what is it that we're actually creating? Who owns that? Who can use it? Who is not allowed to use it, et cetera, et cetera. So you could also see IP as one management system for innovation and creativity. So it's got the different forms. It's an asset. It can be seen as a management system. So there's no right or wrong here. It has multiple ways of being defined, and it very much depends on your perspective of where you're standing, or maybe your role as to how you view IP. I started off by saying it's got different forms. And boy, does it have a number of different forms. So the more common ones are things like patents, which relate to inventive ideas, technical solutions to problems, trademarks, which relate to the names or logos of a business or the products or services of a business. Just walk down the aisle of any supermarket and you'll see all the names and logos of the products that are on sale. It'll give you an idea of how widespread trademarks are. Copyright, which is related to artistic works. I don't know if you're into writing music or making movies or writing books. Well, you have copyright protection on the artistic work that's created. And by the name itself, it talks about who has the right to copy or not copy the work that the artist created. One should go beyond just the artistic work. Copyright also covers areas like software. In the world of IP, the software engineer is seen as an artist. Now, I used to be a software engineer many years ago. I never saw myself as an artist, but that's the way the world of IP looks at creative works, which are more to do with the shape or the ergonomics. Perhaps one of the most famous is the style of a Coca-Cola glass bottle or the shape of an Apple smartphone. So you can get protection on shapes. It's often used in perhaps industries like jewelry or furniture, where you're doing some creative works, but the shape of the object is an important characteristic.
That's an interesting one. That's interesting.
Trade secrets. So if your business has valuable confidential business information, it may qualify for trade secret protection. Know-how, the information that's in people's heads. If you take an employee of a company, what do they know? Now, obviously, some of the know-how may be of no value to the business. If I know, for example, the cricket scores for Durham Cricket Club for the last 100 years, it's probably of no interest to my business. But I might know things in my business like how a certain process works internally or how to best manage the relationship with a key client. That know-how can be valuable. So you can get IP protection on that know-how. Then you've got things like plant variety rights, which might be of interest to people in the agriculture or flower or crop business. Geographical indications, so Cornish green tea, telling you that it's associated with a particular location. Champagne, it's associated with a region in France. So you've got IP protection that's tied to some uniqueness thanks to it being associated with a particular region, maybe the traditional knowledge of the people in that area about how to make the product or whatever, or maybe some characteristic of that location. Domain names, your address on the internet. It's not a physical address. You can't go tell your postman, go to that physical location. You say, well, it's in the internet. It's intangible. But that's a form of intellectual property. It gives you got sole, provided you pay your fees to the domain name register, you have got unique access to that address, or you've got freedom to use that address, how you use it associated with a website or whatever. A semiconductor topography, which is about how you protect the two-dimensional or three-dimensional shapes or designs of integrated circuits, chips in computers. You can go even to more obscure stuff. Cattle breeding rights. If you own certain animals, provided you behave yourself from a health and safety point of view, you've got the right to breed certain animals. So it is extremely broad. And you can see from the examples of the different types I spoke about there that they're quite different. I mean, I started off by talking about inventive ideas. Then I was talking about artistic work. Then I was talking about people involved in making jewelry or furniture. And then I was talking about champagne in France. So One reason it's complicated is because you've got such a large, diverse range of different types. Now, that's not the only complexity, unfortunately. There are other complexities. Some of these forms were created a long time ago. And I don't mean when I was a little boy. I mean centuries ago. Patents are from the Middle Ages and the time of the Renaissance, and when rulers and leaders were trying to encourage innovation and creativity and so forth. First patent in the UK is, I believe, belonging to a Flemish or Belgian national living in the UK who figured out how to put colour into the artistic work on church windows. The first trademark in the UK is a red triangle associated with Bass beer from the 1890s, when suddenly people were mass producing certain products. And he said, I want to be able to tell my beer separate from somebody else's beer. Copyright is from the time of the printing press, when suddenly people didn't have to just handwrite out a copy of a book like the monks did in their monasteries. Now you had the ability to mass produce. And suddenly people, hang on a second, if I can mass produce, maybe I need to control who can mass produce my book or my poem or whatever. So these rules were created a long time ago, long before the internet, long before social media, long before the life we live today. But we're trying to use them in a way that, how do you use those rights in today's world, where you can do copy and paste by 2 clicks of a button? You don't need a printing press. I can copy stuff very easy on my computer. I can use AI to make a fake video that looks like it's you giving this podcast. So another complexity. So first complexity is about the diversity of the forms of IP. Secondly is the fact that some of these forms, not all, have been around a while. The next complexity comes from the fact about how the hell do you get these? How do I get a piece of IP? Well, it depends. There's no simple answer. So some forms of IP, you've got to apply to the government. If you want a patent, you've got to go to the UK Patent Office based on in South Wales, knock on the door and say, I've got this inventive idea. I would like a patent. And then they will take you through a 2, 3 or 4 year process before, at the end of it, which they say, yeah, okay, I think you've got something unique here. I will give you a patent on your invention. Other forms, you don't talk to anybody. Copyright. If I write a piece of music after this podcast and I think it's going to be something, I think I just put together something that's quite unique. I haven't copied anybody else's music. It's my original thought. I have copyright automatically. If I take out my smartphone and take a photograph in a public space of something, I have got copyright on that image immediately. Nobody gives it to me. You have it automatically. However, some forms give you a choice. Trademarks. You have both registered trademarks and unregistered trademarks. So in some cases, I've gone to the government and applied for it. Others I've just taken into use. So if you look at, for example, when you're walking around the supermarket or walking around your high street, you might see names and logos, and sometimes you'll see a little R in a circle next to the name of the brand. And other times you might see a little circle with a TM in the circle. Well, it's telling you the R, that's a registered trademark. That owner or that business went and applied for the trademark, and they've been granted the right by the government. The TM, that business decided to take the name into use of their own. They didn't approach anybody. So it's got certain benefits. They probably did it quicker, didn't spend as much money, but it's not, in a sense, government approved. It's you're doing it at your own risk. So there's the complexity about which forms of IP do I have to go and apply for, which ones are automatic, and which ones give me a choice. Then there's complexity in terms of, let's say I now have the IP. I have a patent or I have a trademark. It varies as to what you can then do with it. So a patent is a negative right. It gives you the right to stop somebody else. It doesn't give you a right to do anything other than, so if I have a patented invention, so I've invented something unique and I have a patent, and I see that you are building a product or a service or a business based on my patented idea, I can come and say, stop. Said, you can't do that. Stop. You're not allowed. You're infringing my patent. Trademark, somewhat similar. If I have the trademark for, let's say, the Apple name, and another company comes along and starts using the Apple name, that's causing confusion to the consumer about, well, am I buying from that person or am I buying from you? I can go to the government and say, hang on a second, I have the trademark. This other person is using a name that's identical or similar and causing confusion. I want him to stop. Right? I may have mentioned it gives me the right to determine who can copy my material. A trade secret gives me the right to go after somebody if they steal. They have to steal from me. They have to misappropriate my secret information, my secret sauce, And then if I have a trade secret, I can say, you've stolen my trade secret. See you in court. So now you begin to appreciate that there's not one thing called IP, and there's not sort of one size fits all. There are multiple different forms. They all relate to some branch of innovation or creativity, but not all the same in the same way. To get it can be as simple as it's instantaneous. I've taken a photograph. Or it can be a 3 or 4 or 5 year process. If I have to go and knock on the door of the government and say, I would like to get this form of IP.
So my question to you would be, how would a business owner, inventor, or someone, how would they know what IP to go after? What should they really be thinking about if they feel like, oh, maybe I need some form of IP here, but what's the starting point?
The starting point is probably some basic education and awareness. You have to go and understand this, because otherwise you can easily spend a lot of money and go nowhere. So you could go and talk to a law firm that specializes in IP, either a general law firm that's got an IP practice or a dedicated IP law firm. Many of them will give you initial advice for free, maybe 30 minutes or an hour of coaching and mentoring. You can go to the government department that manages IP. The Patent Office and Trademark Office down in South Wales have a website, and they have lots of very good educational material about explaining pretty much, maybe in slightly different language, but explaining what I've just talked about there in the different forms and explaining what's involved. There are IP clinics or IP walk-in places in certain libraries around the UK. If you go to the British Library in London, they used to have, I think it's still there, they had an IP section, so you can go in and actually chat to somebody, say, I have this business started, it's related to X, Y, and Z. I'd like to get some IP advice. And I think you may have to schedule in advance, but I think you can go and get some good advice from the in-house person there about things. But I would suggest that you've got to at least allocate some time and attention to it. You've got to, if you're a person setting up a company, say, just like I might spend part of my time focused on the finances or focused on the marketing and so forth. I mean, running a business is like juggling. You've got to get lots of balls in the air, but one of the balls is IP. And unfortunately, it is not well understood. So you've got to figure, okay, well, I've got to understand it first of all, because otherwise I'm in danger of making silly decisions or the wrong decisions. You can easily spend a lot of money on IP and go nowhere, like I said. So before you spend any money, let's do some education and understanding. Now, obviously, the other thing you can do is look to see what other companies in your sector are doing, because they're established. And you think, well, how are they playing the IP game? So obviously, the sector you're in will determine a little bit your IP strategy. If you're in the pharma biotech world, you know a few things. If you just read about IP in that sector, they're going to take patents extremely seriously. They're going to take trade secrets seriously. If it's an over-the-counter drug, they're going to take trademarks very, very seriously. If you take an example like a simple painkiller like Nurofen, well, I suspect at one point, they may not no longer be, but at some point there was a patent protecting that drug. Definitely there's a brand name on that product and so forth. So that will determine. If you're in the music industry, you're probably going to play the IP game slightly differently, because you look at that, you suddenly think, hang on, copyright's going to be really important here, because if I read anything about IP in the music industry, it's all about copyright. But it's also about agreements. If you're a musician, you realize, hang on, I'm signing an agreement with the record company. I'm signing an agreement with a distributor, whatever. So you're thinking, hang on, agreements that have IP clauses in them are also important. Obviously, if I was a music technology company, somewhat related, I might be thinking, well, maybe patents now because it's technology related. If I'm in the food or drinks industry, I'm probably going to take trademarks very seriously. All you have to do is walk through the aisle in your supermarket where they're selling drinks. And what do you notice straight away? All of the containers have a trademark, a logo. So you're thinking, well, because otherwise, how does the consumer know whether I'm buying Coca-Cola or Pepsi? Because it's on the side of the can, and that name is important. But at the same time, maybe there's some secret sauce in my recipe about how I make this stuff. Think about the Coca-Cola formula. So maybe there's a trade secret to be considered here. What makes my recipe about how I make my food or product? I'm probably not going, if I'm a small startup company, I'm probably not going to do everything myself. I might get some manufacturer to build the product for me. I might use a distributor to distribute it. So maybe there's probably going to be agreements between me and other parties to get this business up and running. So again, it's going to be back to, well, what do we say in the agreements we have, upstream, downstream, and sidestream? And what does it say about IP in those agreements? So the sector you operate in should influence to some degree the way you play the IP game and which forms of IP you pay attention to. Now, it doesn't mean you've got to copy everybody else. You you may be very imaginative and you might say, hang on a second, I can do things a little bit different here and be innovative in terms of my IP approach, but at least understand how others in your sector are playing the IP game.
Makes sense. So in terms of then, where do you see the trend of IP going towards over the next few years with the rise of more different industries, different types of organizations? Where is IP? What's the trajectory of IP over the next few years?
So a couple of things are going on at the moment. Some of them are good and not so good. From the 1950s to about 10 years ago was a phrase harmonization would come up regularly in IP discussions. And what that related to was there was an effort to limit or reduce the differences in how IP was played in one jurisdiction to another. So if you were sitting in the UK and you got your head around IP, you went across the English Channel to France and say, well, how do you play? What's IP all about here? You shouldn't see too many differences. So if someone's talking about a patent in the UK and someone's talking about a patent in France, you would say, you're actually telling me the same thing. However, I would argue for the last 10 years, what we've seen is fragmentation. We're seeing greater differences emerge from one jurisdiction to another. So, which means that if you're a UK business, for example, but part of your business strategy is to also sell or market your products in France or Ireland or America, part of your IP strategy now has to also involve understanding, but what are the differences in the various jurisdictions that are important to my business? I can't assume that something that works like this in the UK will work the same way in another jurisdiction. So one trend is not, well, it depends on your perspective. As well, some IP people, I think this is great. It makes life even more complex. But for a business person, it's not so good because you've got to realize I can't assume that something is the same. We are seeing more and more differences in how different jurisdictions treat IP. And I would say one big difference has been in the US and the rest of the world.
It actually makes a lot of sense because I've seen a few things. Give an example of McDonald's, right? And their recipes in the US, they can use specific ingredients with their food, whereas in the UK or in Europe, those ingredients are banned or some way, shape or form. And so I imagine, would that have a level of effect on IP, or is that just...
So it's more health and safety probably rules in Europe, sort of, yeah. But it's an example. I mean, yes, the way IP game is played in different jurisdictions has added to the complexity. That's one trend, fragmentation. The second trend is the importance of unregistered IP has grown. So if you'd asked me to give this podcast talk 10 years ago, I would probably focus a lot on patents and trademarks and designs, the register, where you have to go and knock on the door of the government. Today, when I advise clients, I go, start with things like trade secrets, which is unregistered. Whereas 10 years ago, people would laugh at me and say, well, trade secrets, why would you take them seriously? The law is not very strong. The worst case, you get a slap in the wrist. Today, certain cases, trade secret cases, are criminal in nature. You can go to prison for trade secret theft. So trade secrets, know-how, copyright, those forms of IP, I think, have grown in importance. I'm not saying ignore the more traditional ones, but in your IP strategy now, you've got to think at both. You've got to look at both the IP, like patents and trademarks, the stuff where you have to apply to the government, but you have to think also now about the trade secrets and know-how and stuff like that. The third trend is the emergence of what I would call IP models, which at first glance you may not even think are IP. So, for example, in the world of software, we've seen the emergence of something called open source software. Now, open source, in a sense, it's like proprietary, except when you now get access to that code, you can see the actual lines of code, you can edit it and so forth. And so, if you've got a business that's about writing software programs, you might not all write it all yourself. You might take certain libraries or modules from the open source community and integrate it into your product. But what you need to realize is every time you do that, you also accept whatever open source license applies to that particular piece of code. And if you read those licenses, they're IP licenses. They're all about intellectual property. If you do the same thing with Creative Commons, which is like open source, but more for creative stuff, or open access, which is more to do with data, these models or new ways of playing the game are very much underpinned by IP. Then it's emerged out of academia 10, 15 years ago. When open source first came out, I think people were accusing them of being like communists. I think Microsoft at the time said, this is crazy. Why would anyone make your open source code available for free? This is communism gone crazy. Interestingly, today Microsoft is the biggest contributor to the open source community. So they've changed spots because they've suddenly realized it's not quite free. It comes with conditions and it has benefits over proprietary. I'm not saying one's better than the other. It's just each one's got pros and cons. But if you're in the software industry today, you're almost certainly at least considering open source or using it. But you've got to realize the minute you do that, you now have to take IP seriously. You can't turn around and say, I'll take the code and ignore the license. No, you can't. So that's another trend that's emerged. The fourth trend, I would say, is the rise of China and the Far East. And I don't mean that in a negative way at all. Many parts of me sort of admire what they've done. So if you'd asked me to speak 10 years ago in this podcast, I'd be saying, well, the most patents are in American, European, or Japanese companies. Today, that's not the case. The Chinese are patenting a lot more than we are. A lot more than we are. They have taken it, they have turned completely and realized, hang on, we've also got to master this IP game. Now, why have they got to master the IP game? Because their entire industry has moved from being a sort of copy industry to being, well, actually, we're innovative. We're doing things now where the West is way behind us. So we're innovative and creative. So therefore, there's lots of benefits to them taking IP seriously. Secondly, they're surrounded by lower cost economies, Vietnam, Cambodia, and so forth. So they realize they've got competition now in areas that they probably didn't have competition 20 years ago.
Sure.
And they're thinking, well, how do I fight competition? Well, one way is I can use my IP to protect me. So the trend towards the registered forms of IP being centered in the Far East is a major change compared to, let's say, 15, 20 years ago. Now, I'm not saying bad things don't happen. You still have problems with counterfeiting products, et cetera, but you have that in other parts of the world as well. So we've got to realize that the center of gravity for IP has changed.
I love it. I think it's really interesting that IP isn't defined into just one country or anything. It is very much a global kind of umbrella term, right? Every single country will have its own form of IP and protection, which sometimes you don't think about. You go, okay, well, each country will have its own specific rules and regulations, but registering your IP or in any shape, whether it's copywriting, whether it's patent, whether it's trademarks, whatever it might be, trade secrets, having it on paper somewhere gives you first rights on whatever you have, right?
It depends on whether it's automatic or not. But yes, you've got to think, particularly for a business that's likely to, yes, you might be a startup business that sees its immediate future just in the UK. So you're gonna have your R&D in the UK, you're gonna have your factory, you're gonna have your sales, your distribution, your marketing in the UK. You might have a very narrow view of life, saying, okay, I've only got to worry about the UK as far as IP is concerned. But at some point, you're going to reach a point where you say, well, actually, there's a market for my products in France. And then you've got to ask yourself the question, but what IP do I have in France? Is somebody in France going to turn around and say, you can't use that name or logo because it causes confusion with our name or logo, or I can copy you because you have no patent protection in France or whatever. So you have to think, at least in the jurisdictions that are in your immediate plans and your possible future plans. Now, you asked about trends. Anything else? I suppose the other trend is the tax authorities are getting interested in this. And they're getting interested in it because some clever companies a couple of years ago realized you can do tax avoidance using IP. You can do it. I appreciate that this podcast has been recorded and it's going to go out, so I've got to be careful what I say here. But let me explain in simple terms how to do tax avoidance using IP. And I'm not in any way suggesting you do this, but this is what you can do. So imagine you've got a company in the UK and all your people are in the UK, all your businesses in the UK, you're only registered in the UK and your only dealings are with the UK tax authorities, HMRC. So, and let's say you're a profitable business. So you're going to pay north of 20% corporate tax. Now, if you look east or west of the UK, you've got two countries that have much lower corporate tax rate than the UK. You've got Ireland at 12.5%, and you've got the Dutch. I'm not quite sure what their rate is, but it's lower than the UK. We'll assume it's something similar. But let's take Ireland since we know the numbers. So the corporate tax rate in Ireland is 5%, and the UK is north, so at least 8% difference. So you want to do tax avoidance? Well, hire one guy and locate him in Dublin and open an office there. So you now have a legal entity in Ireland, who doesn't do anything. There's just one guy sitting there, and you've got all your people in the UK, and you're profitable, and you're paying 20+% to the HMRC. But then what you do is you assign legal ownership of all your IP to the business in Ireland. So whatever patents you have, whatever trademarks you have, whatever copyright, whatever trade secrets, whatever yada yada, you basically say, hang on a second, I'm going to move all of that to my Irish division, to this one guy whose only job is to look after the IP. But the rest of the business is in the UK now. So all your IP is now owned by a legal company in Ireland. But the business in the UK needs that IP. It
So
needs
you
to be able to
license
use
it.
certainly needs to license. It needs to, and the Irish guys go, okay, we'll license it back to you, but we're going to charge you a little bit more than whatever profit you're making. So now the English company or the British company is making a loss. It doesn't pay any tax. The Irish company is making a fortune, and it pays 12.5% tax. So the whole business, when you look at it, went from, it was paying 20%, it's now paying 12%.
Yeah. You saved almost 50%.
By just
right
having
there.
one guy.
Yeah.
Now,
Crazy.
the tax authorities woke up. There's other schemes, but there's 4 or 5 different schemes companies started using. And what they were doing was looking for examples of where there were countries with quite significant different corporate tax rates. And then they would play them off against each other. So it suited, for example, companies where a lot of their business was in a high tax regime, but they said, hang on, we'll move our IP to a low tax regime, then have this licensing back or whatever, and we'll reduce our tax bill. It sort of came to a crunch around 2012, 2013, when lots of big multinationals were doing this. And now, it wasn't illegal, but it clearly was immoral. I mean, it was like, hang on, guys, this is not
Yeah.
the
What's going
spirit
on here?
of Islam. So the tax authorities changed the rules. They started exploring the rules, but in recent years, 2020, 21, 24, we have seen countries now change the rules. For example, I know that HMRC tax inspectors went through IP training January last year, because the tax authorities are beginning to realize that actually when I look at a business, yeah, they might have a nice building and they might have a nice lobby in the building and they might have a nice truck, but actually probably the real value is their IP. So the tax authorities are now beginning to look much more closely at companies to say, well, what is your IP and where is it? And who's the legal owner? Who's benefiting from this? And where is it located? And what are the agreements you have between the one guy in Dublin and the rest of your company in the UK? So that's a new trend that suddenly the tax authorities, who are probably more geared up towards physical assets, like, did you buy that truck? How much did you spend on it? Did you pay VAT on it? Now they begin to ask really interesting IP-related questions. This is relatively new, so I think it might be and it probably affects the bigger companies at the moment. But it's something to think about that, at some point the tax authorities may start asking you questions about your IP that you weren't expecting, as opposed to how much money you spent on your Christmas party for your employees or whatever.
Makes sense. Donal, it's been really interesting having this conversation. We have to jump into the next segment of the podcast, which is what we call the Entrepreneur's Room. And that's a series of quick fire questions we ask all of our guests to give our viewers and listeners an opportunity to understand how business owners and business leaders think and operate when running their business. So, first question I always like to ask at this stage is, how are you currently spending your days as a leader of the business?
Even though my background is probably engineering and technology, most of my time these days is customer facing. So I am either in marketing activities or sales activities, which is tough for an engineer, but it's fun. But no, my team, I've got a small team, my business is small, so I let those focus on the technology. I will add no value there. I've got to add value on the customer side.
Love it. And what are the most important metrics for you when running the business?
I suppose we've got 2. We're obviously focused on like number of clients, number of paying clients, but actually in recent times, we've also brought in a metric, which is a number of how many of our existing clients stay a client the following year, a retention of clients. Because obviously it's much easier, if I look from 2025 to 2026, it's much easier for me to take an existing client and if I can keep him as a client next year. Whereas if I've got to go find a brand new client, that's a lot more work. So client retention is a very important metric for us these days.
Love it. How are you currently growing the business? What kind of sales and marketing activities are you doing to grow the business?
Well, IP is rather niche. So you're not going to see me with a product on the supermarket shelf and so forth. So in our business, it's very much about networking, connections, probably a little bit of IP conferences, seminars, getting your face out there. Of course, that's got online, so things like podcasts and so forth and webinars. But it is very much trying to connect to innovative and creative companies or connect to service and solution providers who'll be working with them to see, can I help either their mentor or coach or the company itself. And then more recently, we've also started having links with research universities, which is also an area where they have to take IP seriously because of the nature of their work they're doing. So I think it's probably that. But no, we're not a consumer facing company. So you're not going to see an ad for my company, for example, on ITV television or whatever. That wouldn't work for us.
You've been running the business for a number of years now. What's the biggest lesson you could share with our viewers and listeners today?
So yeah, I created the company Life Nokia in 2009. But we started as a consultancy. So I was a one-man band for 2 or 3 years. Then we decided, actually, I quite like the technology side. So today it's half a dozen people and they're on the technology side developing software. First thing is, when I set up this company, one important rule is I had to enjoy it and my colleagues had to enjoy it. So we're not probably a typical company. We don't, I don't worry too much about whether one of my employees starts at 9 o'clock and finishes at 5 o'clock. I go, that's not important to me. It's like, are you enjoying working here? Are you contributing? Are you enjoying the work you do? Because if they're enjoying it, actually, I will get more value out of them than if I was to stand over and watch them and say, well, where were you at 9:05? How come you're late? So we don't work like that. That doesn't make any sense to us. We are also aware that because we're a small company, so we compete with some big guys. So one of our products, an e-learning tool in IP, one of our biggest competitors is a large French multinational who've got probably hundreds of, or not thousands of people. So we like having competitors and we like having big competitors because we've got to then figure out strategies. Okay, so we've got to run faster than they do. We've got to watch them, observe them, and then figure out ways that how can we be more innovative and creative than they are. And it might be surprising, but sometimes when you're big, you have disadvantages. We can be more agile. We can be more responsive. So we've got to use our size, which is small, to our advantage. So we do look very closely at what the competitors are doing, what's happening in our sector, who we up against. But at the same time, we're also very open to partnering. So we will partner with some competitors. We have no problem with doing that because we're thinking maybe there's a win-win there. So I think it's being agile, making sure my people are enjoying their job. We're learning new stuff. I don't want us to be a company where we're doing the same thing every day. I like variety. And then it's looking and have your antenna wired to see what's happening out there, who you're up against. Can we learn from what they're doing and do it faster or better? But also be prepared to collaborate.
Love it. It's been a great conversation, Donal. I like to end every single podcast with the same question. And that is, if you had a magic wand you could wave to solve one of your business problems, what would that be?
Well, we obviously, like lots of companies, are exploring AI. And we have dipped our toe in the water. We use it a little bit and so forth. But also we recognize we don't have all the skills and competencies in this area. So we are in a sense, struggling, trying to figure out, okay, well, how do we use it in a practical way? And we can't just use it because it's AI. We got to use it because it adds value in some way, shape, or form. So probably my wish would be, I'd like to get to a point where I've figured an answer to that question and then figure out, well, the so what? What are we going to do with AI? We are playing with it at the moment, but we haven't yet figured out a good answer. But we know we've got to play with it. We can't ignore it. It's transforming lots of sectors, and it's absolutely going to transform the IP sector. So I don't want to be sitting here a couple of years now thinking, damn, I ignored this massive technology change going on, and I now look like a fool. I prefer to say, well, at least I dipped my toe in the water and I played with it. And if I didn't fail, I'll say, well, at least I tried. But I haven't yet figured out exactly how to really embrace it. We're exploring it at the moment and just doing some Skunksworks projects with it, but we haven't got a true answer.
Amazing. Donal, it's been a pleasure speaking with you. It's been a fascinating conversation. I really appreciate you sharing your time today. For all those out there that might want to reach out to you and find you, how would they reach out? Where would they go to find you?
LinkedIn is the best way. If LinkedIn ever turns off, my company's going to fail the following morning because it's the way we connect to people. It's the way we manage our connections and the way we communicate. So just find me on LinkedIn. It's probably the easiest. Thanks, Ed, for inviting me as well. I greatly appreciate the opportunity to talk, and hopefully it's made some sense.
Absolutely. It's been an absolute pleasure. Thank you very much again, Donal.
Thank you. Bye for now.